transportation industry, the good, the bad, and the ugly. But before we get started, I'm going to share with you one thing about Vertical Alliance Group and the Infinity Workforce System. We are the online training company dedicated to empowering and streamlining safety programs for transportation companies across the country. With over 850 training videos and a customizable system to automate, track, and document all aspects of training, it's no wonder more than 2,000 companies have chosen the Infinity Workforce System. This system not only makes it easy to build an affordable, best-in-class training program for your drivers, but it also frees up your administrative time while giving you the ability to communicate more effectively and train employees anywhere, anytime. If you're committed to having a training program that proves you value safety over profits, but all the while still improving your bottom line, type the words training in the Q&A box on your screen, and one of our training specialists will reach out to you and share how the Infinity online training system can improve your safety program and make your job easier. Also, after the webinar, you'll be receiving an email that will give you a link to a webinar replay, so you can share today's information with others that cannot attend today. You'll also be receiving a copy of the PowerPoint used in today's presentation. So now let's turn our attention to today's presenter. Our presenter today is Frederick Marcinak, founding partner of Mosley Marcinak Law Group, LLP. They are a transportation and logistics litigation firm based out of Greenville, South Carolina. Frederick represents transportation companies, including both carriers and intermediaries, regionally and nationwide on casualty, accident, and commercial litigation matters, including cargo and freight claims, collections and contract disputes, FMCSA and state regulatory compliance and permitting matters, and insurance coverage cases. In these litigation matters, Frederick has tried multiple cases to verdicts before juries and handled appeals for transportation clients. In addition, Frederick advises clients on business matters such as contracts, tariffs, independent contractor issues, and commercial disputes. Fred's been admitted to the bar in both North Carolina and South Carolina and is a graduate of South Carolina School of Law. So also, before I turn it over to you, Frederick, I just wanted to let everybody know that we'll have a Q&A session at the end of the presentation. So if you have a question, feel free to type it into the Q&A box, and we'll get to it at the end. So without further delay, here's Frederick. Take it away, Fred.
Okay, thank you, Steve, and good morning, everybody. Good to be with you today. And today's topic for the webinar is independent contractors. And you know, this is a topic that I have spoken about for years now, and there never seems to be any shortage of new developments and new issues to talk about on independent contractors. It's just one of those issues in the trucking and transportation industry that it's always there because they're such a big part of our industry and what we do and offer so much flexibility. But there are a lot of legal issues that we need to discuss with independent contractors and be aware of. Independent contractors are an option that if you do it right, can be very beneficial, but if you do it wrong, can cause a lot of harm. So we want to cover some of that today, and I'll show you some of the list of topics that we want to talk about. You can see the various areas of law that we want to try to cover today. Some of this I'll go through quickly. You're going to get a copy of the PowerPoint with the details and all the cases that I'll talk about. So we'll go through some of this quickly and just make sure you understand the major issues, and you'll get copies of the details, and some of it will slow down and take a little more time on. But these are some of the areas that we want to cover today and talk about. I would say, as you start to think about independent contractors, one thing you always want to keep in mind in the trucking industry is always know what's going on with your equipment out on the road. And so here's a slide to remind us of that. Know what your drivers are doing, know what's going on out on the road with your equipment. Make sure you're aware of that. Some funny things can happen out there. So the first thing we'll start with today is the Fair Credit Reporting Act. Now, this is a law that some folks may have heard of, and others maybe not. But This act has certain requirements that it imposes on anyone who runs a credit check on someone, on a consumer credit check. So if you are doing that with your independent contractors, then you have to comply with this act, which means that you have to inform them in advance and obtain pre-authorization for them for you to do the credit check. Then after you take any adverse action against them based on the credit check, you must inform them of that adverse action and give them the ability to contest that. And that's adverse action in whole or in part. So we'll talk a little more about that, what that means, but you have to comply with this act. Now, why do I raise this in the context of independent contractors? Well, this is an act that if you don't comply with its provisions, it might seem innocuous, but there have been recent cases, and you can see here recent penalties and cases where that came up with big dollar amounts for violating the Fair Credit Reporting Act. And the reason is that there are lawyers who look for these violations and then file class actions against trucking companies for violating the Fair Credit Reporting Act, and then that's how they get these big numbers. It's through a class action, and that adds up. If there's a lawsuit against you for every applicant that you violated the act on, that's a pretty big class, and so those numbers can add up. Now, I said, I'm going to go back to the prior slide, adverse action in whole or in part. What that means is not only if you did not hire the applicant based on something you saw in the Fair Credit Reporting Act, but also if there was any adverse action. So if you hired the applicant at a lower rate, if you made the applicant have a higher security deposit because of what you saw in a credit check, if you required more escrow, if there was anything you did to treat this applicant different in an adverse way, then you have to comply with the Fair Credit Reporting Act. We have assisted different companies over the years in drafting the letters that need to go out and the forms to comply with this. But that is something you need to be aware of, the Fair Credit Reporting Act. So I wanted to cover that briefly at the beginning because it's something we see with independent contractors. Let's transition to some recent regulations and coercion. Excuse me. The coercion has been out there for a few years now, so this is really making sure everyone is caught up on this. Rules prohibiting driver coercion. And so the regulations prohibit driver coercion or aiding and abetting violations of driver coercion. And that's coercion with respect to several different things we can see on the slide here. Hours of service, CDL regulations, drug and alcohol testing, hazardous material. Any coercion on any of those areas is prohibited. And there are procedures for drivers to report incidents of any coercion. They have to be reported to the FMCSA, and then there are supporting documents that can be submitted. For coercion to exist, you can see some examples there of how coercion can exist, that the driver's essentially required to do anything that would cause him to violate a regulation, or there's any threat of retaliation or any threat of adverse action based on what the driver is being asked to do. The definition of coercion, where there are threats to a driver to induce the driver to operate under conditions which the driver stated would require him or her to violate more than one regulation. One of the things that we look at with coercion is not only the motor carrier, but the coercion regulations can reach out to brokers, to shippers, to anyone who might have contact with the driver and might want to communicate to a driver certain information. So if you are a broker, if you're a shipper, if you're a carrier, any of those, you would come within these regulations. So one thing we like to do is to make sure we address driver coercion within the various contracts that would come into play. So the shipper contract, the broker contract, we like to have language in there that says that no communication from a shipper, from a broker, from an interline carrier, from the carrier itself to the independent contractor, nothing should be construed as requesting or implying that the driver violate any regulation. The driver must operate in compliance with regulations. So we like to put that in the contract so that we have something to point to. But obviously coercion is something that we need to stay away from, especially with independent contractors where they have a little more freedom and flexibility. We don't want to be getting into coercion there. So that's a second area we see that we want to keep in line. So when you violate regulations, bad things can happen. Maybe not always right in front of the state police front door, but bad things can happen, and so we want to avoid coercion. The next thing I want to cover is whistleblowers and how that works in the context of independent contractors and drivers. And let me just say on coercion, let me just jump back to that for a second. Training your drivers is vital there. Training them on not responding to coercion and not violating the regulations. And let me just also say on that before we jump ahead to whistleblowers, one of the trends that we're seeing with ELDs now we're over, I guess, a year and a half since ELDs became mandatory. One of the trends we're seeing with ELD implementation is that drivers are not committing hours of service violations as frequently. Those are down, but instead we're seeing more speeding violations. So drivers are speeding, they're driving faster to complete their work so they can complete it within their hours of service now that we have ELDs. So there's still an opening for coercion there with speeding, but again, proper training for your drivers, including your independent contractors on these issues will prevent those violations from showing up. Whistleblowers. So whistleblowers, you can see the stats there showing increase in cases reported by whistleblowers. And so what we want to understand in the trucking industry is there's a law called the Surface Transportation Assistance Act. And under this law, safety sensitive personnel in trucking companies who report violations are protected from retaliation. They're whistleblowers and they're protected. And so this does come up. I defended a case in North Carolina on this point 2 years ago on a whistleblower. So this does come up. It is something to be aware of. There can be, of course, legitimate whistleblower issues. So this case, the Scraft versus Cargo Express case, you can see there that the driver reported an air leak, was repaired, failed again, and they refused to fix it, and they told him he had to deal with it and keep going. And then they later fired him, and he claimed retaliation, and the court awarded him wages, punitive damages, and reinstatement. So there can be legitimate whistleblower complaints. I've also seen the Surface Transportation Assistance Act invoked just by drivers who are terminated and who are unhappy, that they're disgruntled, they have agreements against the company, and so unfortunately it can be abused. So you want to make sure you understand it and comply with it. Here's another case, Evans versus Gainey Transportation Services, where we see a driver make complaints about the condition of his truck. And in this case, there were complaints about the condition of the truck. They assigned a new tractor. But in this case, continuing on this next slide, company terminated the driver, and the company actually won in this case because the drivers, the reason for the discharge was the driver's insubordination, not because of the safety complaints. The key on this, and this applies to company drivers or independent contractors, the key on this is when you terminate a driver, whether it's a company driver or an independent contractor, you as with any employment matter, you want to document. So if you're going to say that the reason you terminated the driver was due to insubordination or due to bad performance or due to some legitimate reason to terminate, document it. Make a written record of why you did it. If you're going to say the driver had multiple performance issues or was insubordinate on multiple occasions, do you have that documented going back 6 months, 1 year, 2 years, whatever the time period is? Do you have it documented? So document anytime there is an incident so that you can have the records to support your valid reason for termination. So anyway, another case here, the Calhoun case, discussing termination. And in this case is actually interesting because the driver was apparently, now I've never heard of a driver wanting to do this, but apparently in this case, the driver claimed he wanted to engage in daily vehicle inspections that exceeded the company's guidelines, but that he felt were necessary. So I've never heard of that, but apparently that's what happened here. And what the court ended up saying is, in the last bullet point on this case, is where the employer's inspection methods are reasonable, where they comply with the law, the driver, in this case, it wasn't a legitimate safety concern for the driver to refuse to drive, and they were justified in terminating him. He wasn't protected by that. So that just scratches the surface on Surface Transportation Assistance Act and whistleblowing, but definitely something to be aware of. Let's move on to Fair Labor Standards Act. And I know you all might have some questions on some of this, so send those in and we'll address those. We're going to save some time for questions at the end. Let's talk about Fair Labor Standards Act. This is an important one because it's an important area because Fair Labor Standards Act is the federal law that governs minimum wage and overtime. Now, and it also has a provision for what they call collective actions, which you can think of as a class action. So if you violate the law, a lawyer can come along and organize all of your employees to sue you as part of a class action. But in the trucking industry, there is an exemption for motor carriers. So the exemption here is that if you have an employee whose hours of service are governed by the Secretary of Transportation, which is going to be any driver that operates in interstate commerce, and that his hours of service are governed by the federal regulations, then you are exempt from the Fair Labor Standards Act. So you don't have to pay overtime, and you don't have minimum wage that applies to you. Sorry, it's just on the overtime, not on the minimum wage. So you're exempt from the overtime compensation. So obviously that's important because we all know that the threshold on the overtime, the 40 hours a week, and then you have to start paying overtime. Well, your drivers, many of your drivers go over that 40 hours per week, but they're exempt if their hours are controlled by federal regulation. So that's the law. And of course that applies not only, I say drivers, but it also applies to anyone who is a safety sensitive employee. But it's mostly going to be drivers for our purposes. So that's the law. Now, how it's carried out is the key here is going to be on this slide. You see the third bullet point: used in transportation on public highways in interstate or foreign commerce. So where companies run into trouble on this is when they have drivers who maybe they do last mile, maybe they do local routes only, maybe they are not crossing state lines for some part of their work. Well, that's always the tricky area. So we know that if you have a driver who is never going to cross state lines, that driver is going to be exempt from, or is not going to be exempt from Fair Labor Standards Act, and you have to pay that driver overtime. But if you have a driver who does cross state lines, he's exempt. You don't have to pay him overtime. So what about a driver who does it occasionally? That's where we always run into the problem is, what about a driver who sometimes he doesn't cross state lines, sometimes he does? And that's the issue that we want to discuss. And let me talk about that, then we'll go to this next slide. So what we recommend there is that you have that driver, if you want to avoid the overtime exposure, you have the driver operate across state lines at least once a month. So you have him go across state lines once a month, and make sure you mix that in so that he's going across state lines at least once a month. If you can do it within each pay period, it's even better, but certainly once a month as a minimum to make sure you are exempt from overtime. Here's the other exemption for small vehicles less than 10,000 pounds. if someone is operating a vehicle less than 10,000 pounds, then regardless if they're crossing state lines or not, then they are required to be paid overtime, unless, and you can see the exceptions there, unless they're transporting passengers or hazardous material. So this sort of tracks the requirements for federal regulation. Generally, if you're transporting property, your vehicle has to weigh at least or more than 10,000 pounds for you to be subject to federal regulation. Unless you're transporting hazmat, if you're transporting passengers, you can see the requirements on the numbers there. Same thing that subjects you to federal regulation also brings you out of compliance with the Fair Labor Standards Act. So that becomes a big deal. We see these claims pretty often, so you just want to make sure you're in compliance on those areas. So speaking of exceptions for small commercial vehicles, here might be an example of that on an exception for small commercial vehicles. This was actually taken by one of our lawyers when he was over in Africa. So I thought this is a good slide to include on commercial transportation in Africa. Fair Labor Standards Act collective actions. This is when we talked about, we were just covering those under the class actions. The reason these are so problematic is that you can see the damages here. They're entitled to, if they prevail on these claims, they're entitled to overtime and back pay. They're also entitled to reasonable attorney's fees and costs. To be in these collective actions, they're pretty easy to get in. It's any employee who's similarly situated, and to get out of the class action, they have to opt out. So they're automatically in unless they opt out. And so these can be expensive things. Some examples of cases that we see. Here's a case from the Seventh Circuit. Seventh Circuit is Illinois area. They're headquartered in Chicago. In this case, the question was that where wine was purchased from outside of Illinois and had others ship it to its Illinois warehouse, then these drivers made deliveries from the warehouse to local deliveries inside Illinois. And so the question was, is this interstate commerce or not? In this case, the carrier was kind of lucky in this case, because in this case, the court said that if the wine's coming in from out of state, is hitting your warehouse, and then it's continuing on to a final destination within a short time, that's all really interstate commerce. It's just hitting your warehouse to be kind of deconsolidated and then go on to final delivery. So that's really all interstate commerce, and those drivers making final delivery are part of interstate commerce. So so they did not have to pay overtime. I would not count on that result happening every time. That's a very factual, highly intensive factual result. So don't count on that every time. But in that case, the carrier was fortunate and prevailed on that. So that's Fair Labor Standards Act. Sometimes the next topic we want to move on to, I want to introduce that by saying sometimes with your independent contractors, you have to say the obvious. Here's a sign. This is actually a picture I took at a client location. They had this above a scale in their break room, and it said, to get weight, get on scale and stand still. And I thought, well, I think that's pretty obvious, but they felt the need to say it. And sometimes in the law, you have to say things that are obvious. You have to write things. You have to record things that should seem obvious. And the next topic on independent contractors that I want to come to is a topic like that, and that's misclassification procedure. I want to spend a little more time on this than on the other topics, because this is very important. This is something that we deal with all the time, and that's misclassification. So what is misclassification? Well, independent contractors, we would think of them in our industry as being owner-operators. Independent contractors are different from employees in several areas. Workers' compensation, unemployment benefits, taxes, payroll taxes, and truth in leasing. So an independent contractor in many states, in fact, even in most states, is not entitled to workers' comp. You don't have to pay for workers' comp, and they don't get workers' comp benefits. Now, there's some exceptions that we'll circle back to. Unemployment, you don't pay unemployment tax on them. They don't get unemployment benefits. Employment taxes, you don't pay payroll taxes on them, and they have to then pay self-employment tax. You report their income on a 1099, and they then pay their own self-employment tax. You don't do any withholding for them. So they're different. Now, misclassification means someone is then coming to your company and saying, you have misclassified someone who is an employee as an independent contractor. They should have been an employee. You called them an independent contractor. And so it's either you have to provide workers' comp, or you owe penalties for not having workers' comp, or you owe back taxes on unemployment, or you owe penalties for not doing withholding and payroll taxes. So that's when we see the claims of misclassification. Sometimes it's a government audit. Sometimes it's a former worker who is claiming an entitlement to a benefit. But those are the claims that we see. So you want to get this right. I have had several clients, but recently had a client that I was dealing with on this issue, and this client said, well, my drivers are independent contractors. And I said, well, tell me why they're independent contractors. And the client said, well, because I pay them on a 1099 and not on a W-2. So they're independent contractors because that's how I pay them. Well, I said, where do they get their trucks from? And the client said, well, I provide them the trucks. Well, that's just a perfect example that those folks, they don't become independent contractors because you decide to pay them on a 1099. There's many factors that we're going to talk about, but in the trucking world, if you're providing a truck for them to drive, they're almost always going to be an employee. They're not going to be classified as an independent contractor if you're giving them the truck to drive. Let's talk about why that is. Employee or independent contractor, because in many states, here's a case from South Carolina. South Carolina is a pretty favorable state on this issue, but there's a control test. If you had the right to control the driver, then the driver is going to be an employee. And what the courts typically say in the trucking world is if you provide the truck for the driver to drive, then you essentially have the right to control that driver. The driver can't go drive for anyone else. We can't take, because you provide the truck, the driver can't, while he's employed by you, while he's driving for you, he can't operate for anyone else because you've got his only truck. And you control how he uses that truck and when he comes and goes. And so that's kind of the defining element within the trucking world. But there are other things: right to control, furnishing of equipment, the right to fire, method of payment. We'll talk about those things in a moment. But if you want someone to be classified as an independent contractor, you have to give them more freedom. That's just the consequence of someone being an independent contractor, is that person has more freedom to do his job. You allow the person to choose what loads to accept, what loads not to accept. You give the right for the person even to do a trip lease with another carrier on an individual basis. There's some controls you can put in place on that. Instead of having the right to fire, we also want to watch our terminology. Instead of saying we're going to fire an employee or we're going to hire an employee, you want to say we're going to contract with the independent contractor. We're going to terminate the contract. You don't want to talk about wages. You want to talk about settlements. You don't want to be able to terminate the contract with no notice. You want to build in like a 2-week notice period to terminate the contract without cause. You can terminate with cause without notice, but without cause, you want to build in a notice period. All that implies freedom and lack of control. So in this case, at the end of the day, the conduct of the parties showed that the person was an independent contractor. So that's kind of the first area. Workers' comp claims. This case came up within the context of a workers' comp claim. That's oftentimes where we see these. Folks ask me a lot of times, well, I'm going to hire an independent contractor. I'm going to contract with an independent contractor, and we're not going to provide workers' comp, and he's willing to sign a waiver saying he's not entitled to workers' comp. Isn't that good enough? Well, no, because in no state are you allowed to waive your workers' comp benefits. A waiver is unenforceable. So what will happen is you'll contract with these independent contractors. They'll say, I don't want workers' comp. They don't want it because it's incredibly expensive. They'll sign anything you put in front of them saying they don't want it. But then when they get hurt, they're going to sue you and say, well, actually, I'm entitled to workers' comp because I was really an employee. That's what we saw in this case I just referenced. That's where a lot of these workers' comp claims come from, is a former driver saying, I was really an employee and not an independent contractor. And then once that claim is made, then the state kind of piles on and says, oh, by the way, we're going to fine you because you didn't have workers' comp and this guy was really an employee. Here we saw a case, here's another case where the court allowed a workers' comp claim against a broker because the court concluded that ultimately, in this case, the motor carrier had no workers' comp, and the court concluded that the driver was really operating as part of the broker's business. This is unfortunately a trend that we're seeing. You can see in this case, the courts are taking, there's a theory of law in the construction industry for subcontractors. If a subcontractor on a construction site does not have workers' comp for its employee, then the employee can go up to the prime contractor and claim under its workers' comp. So they can kind of go up the ladder to the prime contractor and get workers' comp. And the theory is there should be workers' comp for all these workers. And if the subs don't do it, then the prime has to do it. Well, unfortunately, courts are taking that and applying it in the broker-carrier context and saying if the carrier doesn't get workers' comp, then the broker has to get, its workers' comp has to apply. And in this case, the court said that, and here's the test, that the so-called subcontractor, it was an important part of the owner's or the broker's business, necessary part of the business, identical activity were performed by the carrier's employees. Now, in this case, though, the driver was an employee and not an independent contractor. In South Carolina, that would not be the case for an independent contractor. But in this case, the employee driver was able to jump up to the broker. Let's talk about North Carolina. North Carolina is a good example of a bad state for workers' comp. North Carolina, the law is every truck driver has to have workers' comp. Independent contractor, owner operator, employee driver, they all have to have workers' comp. That's just the law. And there are other states like that. Illinois is essentially like that. Massachusetts is like that. There are other states that are like that. So in some states, even if the driver's an independent contractor, they have to have workers' comp. There are various strategies for buying occupational accident coverage and having a contingent or statutory workers' comp part of that to comply with this, but to be less expensive. But you have to have workers' comp. So that's just the law in North Carolina. If you're a truck driver and you have independent contractors in North Carolina, you got to have workers' comp. And as I say, we work with folks to help them get substitutes like occupational accident. We can talk about how that works, but that's the law. Now, the problem is that it's bad enough if it's the motor carrier that has to do this. But this case, this Gorey Logistics case said, just like in South Carolina, that if the carrier does not get workers' comp, then the broker, then the driver can claim under the broker's policy, can go up to the broker. And in North Carolina, the driver can do it even if he's an independent contractor. He can go up to the broker's policy and get workers' comp from the broker. So sort of a doubly bad thing in North Carolina. So if you're a broker in North Carolina, you need to make sure that your carriers get workers' comp because the drivers are coming after you if the carriers don't have it. So workers' comp is where we see a lot of this come up, and it's really something we have to work through on an individual basis to make sure you're in compliance. There are options on it, but it's something to think about and to talk about with your independent contractors. Let's talk a little bit about employment taxes, benefits, and labor. We mentioned that that the government comes after. This is an area where we see employees or drivers in the context of employment tax come after employers. So a driver is terminated, claims unemployment benefits. The employer says, well, you were an independent contractor, you're not entitled to those benefits. And then there's litigation. Is the guy an independent contractor or is he an employee? here's a couple of different decisions about whether someone is an employee or an independent contractor. That comes down to that control test we talked about, and but you see the unemployment claims coming from the individual drivers who were terminated. The tax claims, back in the Obama administration, they were pushing hard on misclassification because they wanted more tax revenue. That's eased up a little bit under the current administration, but what it said was what the IRS was doing was auditing and trying to find workers to be employees rather than independent contractors, because then they could hit you with back taxes, payroll taxes, penalties for not withholding taxes and paying money. So we always know the government's going to do anything it can do to get more revenue. That's what can happen, and that can be bad news for a company. These were various interpretations. You can see this interpretation from 2015, trying to redo the tests on making someone an employee versus an independent contractor. You can see the factors there. There's also, just kind of moving quickly, there's an IRS 20-point test. Now, who's surprised that the IRS has a 20-point test? Nothing easy ever came out of the IRS. But you can see all the different factors that they say they're going to look at to determine whether your worker is an independent contractor or an employee. Here's the rest of the 20 points. So it's very difficult to know and comply with all of these factors. The basic thing is, don't supply the truck to an independent contractor, and give the independent contractor freedom of action, freedom to make some decisions. There's also a 6-point test that we can see here, so that various different tests for determining this misclassification. These tests matter. Here's a case where this Green Fleet case where the National Labor Relations Board charged the company with almost $1 million fine for misclassification and retaliation. These matter. They cost real money. So that's the point here, is understanding how you classify the employees. Now, if you were to say to me, well, we do a lease purchase program with our independent contractors, so we do a lease purchase of a truck with them, I would say there's a right way and there's a wrong way you can do that. If you're doing it the right way, you are in compliance with the law, and that's not going to make your worker an employee. If you're doing it the wrong way, then even if you're doing a lease purchase and not just providing a truck, your worker's going to be an employee. So right way and wrong way to do that, and we can work through that on an individual basis, but lease purchase can work if you do it the right way. What message am I sending? That's one thing you always need to think about as a company. What message am I sending with the way I'm doing business with my operations? Here's an example of a good way to send a message on the sign. Looks like it's got some distortion there for some reason, but septic tanks pumped, swimming pools filled, not same truck. Okay, they understood the need to send a clear message here. That's what you need to understand with your independent contractors. More cases where we can see that play out. Here's just a case on proper classification, where a court went through the factors. So we talked about the 6-factor test. A court went through the factors and to determine whether the person was an employee or an independent contractor. If you have a court going through factors to make a determination, you never really want to be in that position. That's always going to be a difficult position to be in. So those factors there. Another case where they were doing that. In this case, this is one of the rare cases where the court went through the factors, and then in this case determined that the worker was at the end of the day an employee because of how all these factors were set up. So Sears Home Delivery set up had a delivery and set up affiliate, and the court said you can't call those folks independent contractors because they're essentially doing your work and you had the right to control what they were doing. So not a good outcome there. FedEx, this is no inside knowledge, it's just public knowledge. FedEx has had issues with this FedEx Ground has traditionally tried to contract out kind of the last mile delivery to the individual offices or homes, but it's required the contractors to wear uniforms, to drive trucks that say FedEx. It's had appearance standards. It's told them when to deliver the packages. So, FedEx might bring the packages to a warehouse. They're then deconsolidated, put on individual trucks for delivery, and FedEx would say, those individual trucks, that's all contracted out. Those are not our employees. But you can see these control tests that were, when the court goes through the control tests with these factors, FedEx was not winning these cases. So we see that especially in California. Misclassification is a big deal in California. I want to talk about that a little bit now. Hub Group said we're going to be moving to only employee drivers in California, not independent contractors, because of the litigation in this area. Other carriers, a lot of the LTL carriers now have a California accessorial. So if we transport your freight into California, we're adding on a fee because it costs so much more money to do business in California because of the legal requirements. Let's talk about California a little bit. Misclassification case, $2.2 million in damages. The factors they looked at there were the carrier supposedly had independent contractors, but uniforms, insurance mandated by the carrier, assignment of loads mandated by the by the carrier. California courts said these guys, in our opinion, are employees and not independent contractors. Part of the bad trends in California. Here's another case. Again, the court, the carrier lost on misclassification, and so you can see the factors here that the court looked at. Again, controlling the work that the drivers were doing. Massachusetts, I want to detour to Massachusetts just for a little bit to talk about this ABC test. So this so-called ABC test, and the ABC is just because there's factor A, factor B, and factor C. So think about this test in your trucking company. In order to be an independent contractor under this test, A, the driver has to be free from your control and direction. Well, maybe you can pass that element because you give the independent contractor more freedom on when to accept loads, not to accept loads, and other things. So maybe you can pass that test. But B, the worker does work outside the usual course of business of the employer. And C, the worker is in the same business as the employer. As a trucking company, you're never going to pass B and C because the independent contractor driver is not doing work that's outside the usual course of business of the employer. They're always doing the same work that your employee drivers do. They're always doing work that is a part of your business, which is delivering freight, transporting freight. So you're never going to pass B and C. You're always going to fail those elements, which means in Massachusetts and, next slide, California, your workers are always going to be classified as employees and not as independent contractors, because California, in the Dynamics case, has now adopted the ABC test. And so in California, it's going to be extremely difficult for your workers to be classified as independent contractors. So that's the law in California, and it's a difficult decision, but that's where things stand in California. So some of the lessons here, again, we talked about sometimes saying the obvious, saying what you mean. Here's another example of that. See the sign here, do not drink water. Should be fairly obvious. Somebody felt the need to say that, do not drink the water. So sometimes we have to say those things. Dual operations, and this is where we can think a little bit about training and how you operate with your independent contractors on training. You have to provide training to your independent contractors. You can't assume that they're fully trained, they know what to do. You can't just not train them. But you have to think about how you treat them differently on these different areas. So Some of these areas you treat your independent contractors differently. Some of them you treat them like your company drivers. So training and safety meetings, those are things your independent contractors need to come to, as well as your company drivers. They're a part of the safety culture of your company. You give them training and you give them safety meetings. Now, you don't have to give them training on internal HR matters, benefits, leave, things that are specific to employees. But on safety issues, absolutely you give them training. On dispatch, compensation, most of these factors, you will treat them differently from your employee drivers. So you dispatch them differently. In other words, they have the right to accept or not accept loads. Their compensation is different because you're compensating them based on a settlement and not based on W-2 wages. The performance evaluations are different. Instead of disciplining them, instead of having a progressive discipline policy, your contract with them is going to control your right to terminate the contract, and it's going to control the right to terminate and provide when you can or cannot terminate. And it's also an option, gives you the ability to use safety bonuses for compliance rather than discipline, because discipline is something that is done with employees, not with independent contractors. The paperwork's different for them. The policy and safety manuals are different for independent contractors. We talked about, on this idea of misclassification, about lease purchase, and here's where I wanted to circle back to that. Lease purchases can work if you comply with certain things. Here are a few of those factors, but you have to be careful on how you allow the owner-operator to lease the vehicle to other carriers. So that always comes up. We're going to do a lease purchase. We're going to do a lease purchase with the driver for this vehicle, but he's got to drive for our company. He can't go take the vehicle to another motor carrier. And I understand why you want to do that, but you've just controlled him. You've just told him you can't drive for anyone else, and you've just really severely hurt your ability to claim that he's an independent contractor. You should allow him to purchase the vehicle at any time for full market value. We like to minimize the use of full service leases. Full service meaning we do all the maintenance. We like to push the maintenance onto the independent contractor. That helps distance him from the motor carrier, and then using third-party companies to set these leases up through. So there are ways to do these and make them work, and we mentioned that earlier on lease purchases. Bad states for owner-operators. You can see some of those there. We got California in all caps, but there are a number of states that have bad decisions on owner-operators. If you operate in those states, we can talk a little more about that, but that's a sampling of those. Let's jump on to truth in leasing now. This is something you might have heard of. Here's sort of the hodgepodge of what your independent contractors see out there. Truth in leasing. Lawsuits can be filed, class action lawsuits can be filed. Potential problem areas you can see listed here in leases. So essentially what truth in leasing is saying is, number one, any independent contractor equipment lease has to comply with federal regulations. We'll talk more about that. Number two, it has to be accurate. You can't do things, you can't charge drivers for things that aren't in the leases. You can't violate the terms of the lease. They have to be accurate in their terms. So you can see some of the problems area. Do you have your escrow correct? Do you have all your chargebacks listed? Are you doing a lease purchase? Are you forcing them to purchase equipment or insurance through you or not? The law says you can't force them to purchase that stuff through you. What do you do with fuel surcharge and accessorials? That's a big one, by the way. We see lawsuits. The company didn't pass through 100% of the fuel surcharge and the accessorial to me. Well, are you required to pass through 100% of that, or can you withhold some of that for the company? Think about that. Are you required to pass it through 100%, or can you withhold some? And the answer is you can do either. You just have to specify it in the lease. The lease has to say, are you going to pass through 100%, or are you going to withhold some portion of that? Okay, what about fuel advances? What about if you advance fuel? Can you charge an administrative fee or a markup? The answer is yes. if you disclose in the contract that you're doing that, if you tell them you're going to do that. Do you have to pass along rebates that you receive for fuel purchases for the use of your fuel card to your independent contractors? It depends on what your contract says. You can specify that in the contract. Some contracts that where I have this conversation, we talk about doing that you will pass along any at pump rebates, but not any overall volume rebates. So there are different ways of doing that, but the contract just has to be accurate. These can be big problems, lots of money, in truth in leasing lawsuits. So be aware of those things. Your contract, you have to know what's in the contract. You have to read the contract. Okay, this is kind of a funny picture because I'll tell you my theory on this. I like to write contracts that are short. I don't like long contracts. I like to make them short and sweet to the point. I will tell you that the independent contractor equipment lease agreement, which we're going to talk about now, is one of those contracts that it just has to be lengthy. You can't do it in under about 10 to 12 pages. If you have one that's less than that, it's just not protecting you as much as it needs to be. So mandatory provisions under federal regulations in 49 CFR Part 376. You can see some of these listed. I'm not going to call them all out, but you can see some of these listed, some of the things you have to have in your independent contractor lease. Here's some other ones that you have to list in your independent contractor lease. Let's talk about a few of these specifically. Insurance. You must provide a copy of the policy if it's requested, and you must provide a certificate of insurance if it's requested. On insurance, you want to give your contractor the right to purchase it through you if he wants to, but he's not required to. If he wants to go out and buy his own insurance, he can do that, or you can give him the right to purchase it through you. How you're going to handle cargo and property damage claims, that has to be covered. Are those going to be paid by the contractor, or is the company going to pay those? Escrow, the important things there is if you're going to establish escrow, you must pay interest. That's required by law. You must specify what can be deducted from the escrow, and you have to provide an accounting if they request an accounting. So let's take a look at some sample language as we think about this. So you have to describe the equipment. Here's the language. Here's some sample language on how you would describe the equipment. Now you can see here, carrier shall have exclusive possession, control, and use of the equipment. That sounds like control. So we say this statement is made to comply with the federal regulation and should not affect contractor status as an independent contractor. So we can say we're only saying that because the regulation says we have to say that. It doesn't mean that the guy's not an independent contractor. Contractors' employees. What if your contractor, what if it's not just one person, one truck? What if your contractor has 2 or 3 trucks and is going to hire drivers to operate those trucks? Well, then you've got to deal with the contractor's employees because those drivers are the contractor's employees. And so we're going to say the contractor is the one who's responsible for them. He's got to pay them. He's got to do all the withholding, pay all the taxes. That's his issue. So we're going to say that in the contract so that the contractor can't come back and say that we had some responsibility for those employees. Wages. Contractor is going to pay those wages to his employees. Now, those are wages. They're not settlements because you're making a settlement with your contractor. He's then paying the wages to any employees he has. Those are his responsibility. What about workers' compensation? That has to be addressed in every contract. How is it allocated? Do they have to have workers' comp? Are they allowed to have occupational accident coverage? Are you going to allow them that? Are you going to mandate workers' comp? Are you going to mandate neither? And see, this one says it's required by the agreement to obtain workers' comp, or we're not prohibited by law occupational accident insurance. So we allow the option there in certain states for occupational accident, but you've got to think about how you're going to deal with that. Termination. What gives you the right to terminate? Here you could terminate for cause without notice. And here are some examples of a for cause termination. Failing a drug test, seeking to compete, failing to maintain insurance, failing to comply with the agreement. What happens if they violate the agreement? Again, here we talk about that you have the right to immediately terminate the agreement. Insurance, that has to be covered in every contract. Here we have the traditional language, carrier will maintain insurance for the protection of the public. Now that's saying your standard public liability insurance, your motor carrier coverage, the carrier will provide it. Many companies now are saying, no, we will provide it, but we're going to bill that back to the contractor. Can you bill a premium for your liability coverage to the contractor? And the answer is yes, if you disclose it in your agreement. We'll get the insurance, the liability insurance, and we will bill you a prorated portion of the premium for your vehicle. That is allowed. Some companies do it, some don't. It depends. It's a business negotiation. If you think you can do it and it's not going to cause you to lose drivers, some companies like to do it. Others say no. To be competitive, we need to provide the insurance and not charge the driver for that. So that's just a negotiation item. Liability for violations. We're going to say that if the contractor violates any rules or regulations and the carrier is fined, then the contractor has to reimburse for that. These are, again, just sample requirements. And here is, again, insurance language, liability coverage. We talked about non-trucking. Are you going to require your driver to maintain non-trucking coverage? We recommend you always do that. And you give him the ability to purchase it through you or to purchase it on his own. So some overall tips on this issue with the contracts and how you treat your contractors. Here are just some tips on that, on letting them become independent contractors and not classified as employees. How you might do that. Some specific things there. So allow them to refuse loads. Allow them to haul for others via trip lease. Now that one's always a little controversial. We recommend you do it, but there are certain requirements that we're going to put in place that they have to give you advance notice. They have to de-identify the vehicle and re-identify it for the other company. There's some requirements we put on that that they have to comply with to do that. But allowing them to haul for others, if they meet those requirements, is a very good way to show distance between you and them and to make them independent contractors. So those are the rest of the tips. You can see those on the screen. But I think we're coming up on an hour, so wanted to save some time for questions. So Steve, I'll turn it back over to you.
Yeah, Fred, thank you very much. I appreciate it. Can you hear me? I just wanted to check and make sure.
Yes, I can hear you fine.
Okay, perfect. We have a question here from Kurt. Kurt's asking, did you say that last mile drivers who continue the movement of interstate freight but do not cross state lines are considered interstate and exempt from overtime?
That is what, yes, that's what I said, and that was that case out of the 7th Circuit in Illinois that said that. Now, the caution I would give you on that is that's very fact specific. So that depends on if it's a true last mile where freight is coming in, is staying in it's getting cross-docked and then immediately going back out for delivery, yes, they would be considered to be an extension of interstate commerce and so exempt from overtime, yes. But if that freight is hitting a warehouse and it's not cross-docking and going back out, it's getting stored for some period of time, then they're not going to be considered in interstate commerce. The freight stops and then it gets handled later on a local move. They would not be exempt. Where you draw the line between the two of those is very fact intensive. So we probably need to talk about a specific situation, but it's a fine line there. But yes, if it's truly just freight that's coming in, getting cross-docked and going back out, they're going to be exempt from overtime.
Great, thanks, Fred. I got another question here from Randy. Says, if you have an independent contractor with multiple trucks and hires their own drivers and that contractor has no work comp, can their drivers come back on the carrier for benefits?
In most states, yes. In most states, that is going to be the rule. And in that way, it's ironic, Randy, if you have excuse me, an independent contractor who works for you, and you don't get workers' comp, you have less exposure than if you have an independent contractor who has employees who work for him. those employees can usually jump over the head of the independent contractor and come to you for workers' comp. So yes, that is going to be the case in most states. Anytime you have a contractor, we like to see what we call one person, one truck. If you've got an independent contractor, one guy, one truck leased onto you, that's very straightforward. Anytime you start having what we call fleet leases, where you've got an independent contractor who's got multiple trucks and puts employees in those trucks, that opens up more problems. You can do it. There's just more potential exposure. And so, yes, in most states, they can do that.
Okay. Here's another question. This is from Rick. Rick says, what requirements do motor carriers have to ensure owner-operators are legally able to work in the U.S.?
Well, technically speaking, as a technical matter, because you're not employing them, you're contracting with them, they're not subject to the same verification as employees because you are not going to be doing withholding and payroll. That's the legal requirement. Now, whether, you certainly have the right to go above and beyond that. And some of it depends on what your insurance might require as well. You may have issues with insurability, but you don't have the same employment verification requirements with independent contractors that you do with employees.
Okay, great. Here's another question. If the company provides the truck but charges a lease payment fee, is the company still providing the truck to the contractor under the law?
The answer is yes. And I'm going to make some assumptions here. If by the company you're talking about the motor carrier, if the motor carrier is providing a truck to a driver and the driver is paying a lease fee for it, then that driver is going to be considered, the company is providing a truck and the driver is probably going to be an employee. Now, if the company has an affiliated leasing company, a separate company that it may have common ownership, that is leasing a truck to the driver and the driver's paying a lease to that leasing company, and then the driver's leasing the truck onto the motor carrier separately to drive for the motor carrier, that's okay, and that's not considered providing the truck. But you can't have the driver paying a lease fee to the same company that's also the motor carrier that he's driving for.
Okay, great. Here's a question. We had a couple like this. When you talked about training, safety training for independent contractors, and you said that was okay, can it be required that they complete safety training?
Yes, that can be required for independent contractors. Safety is an issue that you have a responsibility for employees and independent contractors. And if you did not require it for independent contractors, it could in fact cause you to have legal exposure in an accident case. So yes, it can be required.
Is that generally written into the lease agreement or the contract?
It's usually not written into the contract. It's usually just something that the company requires and says, but it's usually not written into the contract.
Okay. But it's not going to cause someone to be an employee if you ask them or require them to participate in training.
Not if it's safety training. If
Right.
it's training on other things, if it's training on, personnel or, company HR policies or something, then that's different. But if it's safety training, then no, that's not going to cause that.
Okay, great. We have another question here. This is from Michael. Michael said, you mentioned lease purchase done right. What are examples of lease purchase agreements done wrong?
The main one is the one that I already answered, where you try to do a lease purchase with only one company. So if you've got one company that's a trucking company, they can't do a lease purchase with a driver and then have him turn around and do an equipment lease back to them to operate the equipment for them, because that's just circular.
Right.
So you have to create a separate leasing company, have them do the lease purchase to the driver, and then the driver do the equipment lease to the separate motor carrier. Another example would be where you do a lease purchase, but you control the driver too much. So you do a lease purchase from the leasing company to the driver, but you tell the driver, you have to lease only to our motor carrier, nobody else. You can't take the truck elsewhere. You have to do your maintenance only with us, with no one else. Where you start imposing requirements like that in your lease purchase, then those are done wrong, and those aren't going to hold up.
Great. Awesome. Fred, I don't see any other questions coming in, and I know we've gone a little over an hour here, but I wanted to tell you this has been really fantastic information, and to all of you still out there, I know that we had a few minutes of audio issues right at the very beginning, and I apologize for that. But everybody will be getting an email with a link to the full recording, so you won't miss a thing. And I'm assuming, Fred, the contact information you had up at the beginning, if somebody has a question, they could call or give you an email. Is that okay?
That is perfectly fine. Yeah, and I would love to do that. I'll put that back up briefly.
There you go.
We do also, we put out a quarterly newsletter from our firm. If I can do a shameless advertisement for our firm, we put out a quarterly newsletter on transportation, and we'd also do our own webinars. So if you want to get on our newsletter list or our webinar list, shoot me an email. We'll get you on that list, and would be glad to also answer any individual follow-up questions.
Fantastic, Fred. Once again, I appreciate you joining us this morning. Thanks to everybody out there that logged in, and we hope that you come back and join us for our next webinar next month. So thank you all very much. Thanks, Fred.
Okay, thank you.
All right.